In the 20th century, there have been a number of debates about the relationship of the Quran and the Sunnah. These debates have by no means come to an end. While there are many types of views on the subject, a broad classification yields three types of trends. The first is the view of those people who wish to give greater prominence to the Quran and wish to emphasize its coherence. Their view appears to be that only that Sunnah is to be accepted as authentic that is compatible with the Quran. This is an extreme view and, if applied, would demolish a greater part of the Islamic legal system as it exists today. On the other extreme are those who maintain that the acceptance of a Sunnah should be based on its chain of transmission. If the chain is sound, the content of the tradition should be accepted and absorbed, whatever the consequences for the legal system. In other words, they relegate to the background the importance of examining and analyzing the content of the traditions. And the third group consists of those who give importance to the isnad or chains and also to the content. This third group appears to represent a kind of middle path. However, the situation here is somewhat complex. Within this group may be those who are inclined to check the content against the Quran alone, and this takes them closer to the first group. Then there are those who focus more on the chain of transmission and check the content not against the Quran alone, but also against the Sunnah, that is, other traditions. In case of conflict, however, they accept the content of the conflicting tradition as an exemption from a broad rule, but then, following the Shafi rule, they consider the exemption as a broad principle in itself. This takes them closer to the second group. To understand the problem, a few things have to be kept in mind. First, the Sunnah, like the Quran, deals with life and not with the legal system alone. The meaning derived by a Sufi from a tradition may not be same as that understood by a jurist. Second, a Muslim may be ready to follow any tradition in its literal sense out of his love for the Prophet, peace be upon him, and his Sunnah. But the same person may understand the same tradition in a different way if he is asked to make law for the subjects to follow. His approach may be different. Here we are concerned with what is binding and generates obligatory law. A sound method, therefore, has to be followed. A method that ensures that the intention of the lawgiver is implemented and at the same time, taking care that it will not upset or unduly disturb the functioning of the rest of the legal system. Having said this, we notice that there has never been and, perhaps, there never will be a single system even for the law. When we examine the methods of the jurists and their different approaches to the Sunnah, we find that there are two broad methods, as follows. The first method is that of the literalists, who gave more importance to the isnad or chains of transmission. Once a sound chain was established, they tried to implement the content of the tradition even at the risk of losing analytical consistency. The second method was followed by schools who preferred the analytical method based upon the general principles of the law, whether these principles had emerged out of the Quran or the Sunnah. It may be noted that the first method may be more suitable for what may be called the fixed part of the law, that is, matters of ibadat, hudud, and qisas, as well as some other areas of the law that do not accept change and which deal with the relationship between the subject and the creator. The second method, on the other hand, is more suitable for the rest of the law, where the relationship is either between individuals or between individuals and the community as a whole, that is, the state. In the second area, reason has a wider role to play, and the examination of the content for analytical consistency is essential. The second method was refined further by Ghazali in his theory of the general purposes of the law. He suggested that any new principle made for the law must not only be checked against the established general propositions or principles of the law arising from the Quran and the Sunnah, but also against the purposes of the law, which are taken to be the ultimate general principles. This method ensures the sound development of the law along with the implementation of the overall intention of the lawgiver. The method is equally valid for the reconciliation of traditions. The method also explains why Abu Hanifa would sometimes accept a tradition that did not have a sound chain of transmission. The reason was that a broad general principle, compatible with the tradition, was already present within the legal system, and the law would have still been the same even without the tradition. For the jurist, this may be the only method that can be followed.